Oh, God. Okay, let's wait on a few more and then we'll start.
Yeah.
I mean, maybe you all could find it too. I'll give you all the name and you probably could pull it up.
Okay.
Yeah. There's only the Bahamian ones just be hard to find sometime. Okay, there's some rules and principles in here that you all may wish to just highlight. And in this case, 4, 5. Okay, it says 2 persons, so let's give them two more minutes. It's 12:33. Because I know people have things to do. So even if they're on the road, they could still call in.
But just set out on the road early like me, so I could get back in time for this juicy glass.
I'll take that comment with a grain of salt. Oh, you're too much. Okay, 1, 2, 3. Okay, we almost there. They're getting there. They're coming in.
Afternoon.
Good afternoon. Just waiting. Let me see. Oh, okay. We're getting there. 4, 1 more and we're good to go. Let me see. I actually found this case one day when I was looking for some African news. And I saw there was a lot of comments on the African newspaper about this matter. And so I had to find this case. In which they won. Okay, so let's get started. So that's 1, 2. Bar is on twice. I don't know why. Okay, so let's talk about risk. Okay, one of them dropped. So this chapter could be taken from different angles with regard to managing risk. So we all know that all entities now have to conduct a risk assessment. So you could take it from the view that your company has to conduct a risk assessment. And that risk assessment can be an enterprise risk assessment, or you could be just responsible for the corporate governance section of the enterprise risk assessment, or you could be just responsible for the AML portion, or you could just be responsible for the operations risk assessment of the enterprise risk management. So that's one way that this can be approached. So either you are in risk and you're responsible for the enterprise risk management, or you're in your respective department and you're responsible for risk assessment.
Excuse me. Sorry, I might have been a little late. I don't know what we're talking about. I heard about the
about
risk
risk.
management.
Yeah, we're talking about risk. I was saying that you could take this chapter in different ways.
Okay.
One, you can look at it as being able to manage an enterprise risk management process, because all entities now that are regulated, whether under the Compliance Commission, the Securities Commission, the Central Bank, you're required to conduct a risk assessment. So an enterprise risk assessment covers all of the risk in your company. Or you could be the person who is in compliance, and you'll be responsible for ensuring that all of the risk from the front line have been addressed. So you'd probably be the first person to do the assessment of the AML risk. Then you would look at corporate governance, and then you would look at operations. Of course, operations would be done by the COO. If you are the corporate secretary in your organization, then you know that corporate governance will fall under you. But remember, compliance plays a role in every department of the organization. Now, the first thing you have to realize about managing risk is you always have to know who has the history of the organization. That's the key person who can tell you whether or not policies and procedures are in place, or where changes are necessary, or how things actually operate. And that's why succession is key when it comes to running a company. That risk intelligence is very important when it comes to managing your risk, because you have to know all of the stories or the events that happened over time in order to be able to identify and mitigate against risk, whether that risk is present or that risk is foreseeable. So risk management is all about dealing with the threats, and that's a threat to your company itself. If you're a director or an officer or company secretary on a small company, or you're a part of a financial corporate service provider that's looking at the threats from the company itself as a whole. So then you'll be looking at your products and your services, the jurisdictions in which your clients operate. So the first thing you have to realize that for risk and policies and procedure, risk governance is at the top. The board is responsible for the governance of the organization. They are the ones that approve the policies. Senior management will approve the procedures. And in every organization today, unless they are very small, they try to purchase a tool that can deal with enterprise risk management. You have to have that infrastructure in place whereby things are automated today. And of course, each department has to take ownership of their risk. So if you look at the first diagram, it speaks about the first line, the business unit. That's the first line of defense. The second is risk management and compliance. And the third is internal, external audit. Depends on the size of the organization. Then you have committees that report to the board. You can either have a risk committee, you can have an audit committee, you can have a compensation committee, the different committees, and they report to the board. So before you even start in writing or decide to develop your enterprise risk management and the various sections within your organization, the board has to determine what is their appetite for risk. How much risk are they willing to take? And then based upon that risk and that appetite level, that is disseminated through the various policies. So in most instances now, a lot of organizations have they have a zero tolerance for a certain risk. And they do not set a budget aside for such future expenses because they have zero tolerance for it, which means that staff must comply with the policies and procedures. And in some instances where they have zero tolerance, it could actually end up with an employee being dismissed. So what are the type of risk that you would see in a company? So at the board level that's responsible for corporate governance, you will see strategic risk, because they are responsible for developing the strategy and making sure that management implement the strategy. So based upon what they set out, their objectives, their tone from the top, you can have strategic risk. You can also have operational risk, and that can happen when staff do not follow policies and procedures or they exceed limits. Also, when it comes to company, you can have money laundering risk. So that means that you have to comply with your AML policy and procedures. And bear in mind, as we go through each one of these risks, there are fines and penalties related to these risks. And then that can lead to financial risk. In addition to risk coming from fluctuations in the market that can impact the investments. Then you have reputational risk. And reputational risk is one that can really impact a company in many different risk areas. And so from a corporate governance perspective, the board has to be aware of all of the risks that are inherent in its business. And again, that's based on the products and services that they offer. And you have to look at all of the stakeholders in your organization. So normally what a person who is in charge of risk management would do would be first identify the inherent risk, which are the major risk. Then they would look at other significant risk, and then they would have the residual risk. Because remember, if your policies and procedures cannot mitigate all of the risk, you're going to have residual risk. And you have to look at the impact of that residual risk on your company. So what you try to do is you have to look at the structure of the organization. You have to look at the policies and procedures that are in place. Are they adequate, or do they need amendments, or a new policy needs to be put in place, or whether you need to write new procedures, where the structure has to change. All of those things you have to look at, in addition to changes in the law, changes in the way in which business operates around the world. All those things impact your organization and the rating of your risk. Any comments?
When you were talking about risk management, you had to determine the three, you mentioned three risks, the first being the inherent risks, and then the third was residual. What was the second?
Any significant risk. See, there are certain risks. Okay, let's say incorporating IBCs or a CAC company. What's the inherent risk? And remember, the inherent risk means that it automatically arises with the product or the service. So in corporations of companies, what's the inherent risk?
I guess the client, knowing your client, and the whole face-to-face, and to know that what their intentions are with the client, and the fact that you don't know really the operations of the company or what they're doing with the company. You just provide the registered office and agent.
Right. So interpret that into a risk. What is that risk? What risk does the FCSP face in incorporating companies based upon what you just said? What's that risk?
I mean, I think the primary risk is reputational in that case.
Yes. And what's a significant risk?
I mean, like what the person the company would facilitate, like money laundering or terrorist financing and all that sort of
Yeah.
stuff.
Uh-huh. And what would be your residual risk?
I don't know.
Well, it depends. Your residual risk could either be regulatory.
Right.
Yeah.
Financial, I guess, loss of
Yes, could be
client, I don't know.
yes.
Mhm.
And that's how you have to look at every product and service that you offer.
Hmm.
So you can see whether or not the company is mitigating against all of its risk. Because don't forget
Right.
now, at the end of the day, once you've completed your risk assessment under your major areas of operation, the results of that will be able to determine from a board level whether or not the company is going to be able to meet its objectives. It's also going to tell them where there are gaps in the organization.
Right.
So it's
Okay.
not an easy fix, because you really have to sit down and think, and make sure that you identify and really assess what are the risks. It is subjective in a way, but it's something that has to be done, especially when it feeds into the national risk assessment process. So if we take incorporation of IBCs, there is a process to go through to determine the risk. So the risk assessment talks about identifying the risk. Then you have to analyze it and then evaluate it. Now, based on that, then you have to think about how you're going to monitor it and review it. So that means that you got to look at what are the processes you're going to put in place to review this risk. Does that mean you're going to be doing reviews on your company, on those IBCs that you incorporate on an annual basis, biannual basis? We know it is done on a risk-based basis, but there may be other triggers that you want to put in your policy to make sure that you are monitoring and reviewing these risks. And here comes the automated system.
Oh, I was
Because
just
what
gonna
you
ask
put-
you what kind of triggers.
Yes, so once you put your information in an automated system, the system should automatically tell you when any one of those either members or directors or officers' name have any negative comments, or the system may pick up the name and think that they are PEPs, or they may pick up the name and think that they are on a sanctions list. And that's why having a tool is so important in today's world, and being able to help you monitor and review your risk. And then a part of all of this is being able to communicate what your risks are, how you are addressing them, where your gaps are, and what you intend to do. So if your risk department is separate, risk would then come to you and say, what are your risks? Are there any gaps? How do you think that the little square that they use, what is the likelihood of this risk either getting worse, getting better, getting lower? So it's not a full-time job unless you are in risk, but it is a part of the compliance function to assist in risk assessment. Another part of dealing with this risk management process is that all policies and procedures have to be documented and stored in a central location. Every staff member should sign off or acknowledge that they have read these policies and procedures. That confirmation should be provided to the board. Each procedure or policy should have a renewal date. Depending on the policy and depends upon the external changes, it is either annually or every 2 years, every 3 years, and then you would put within your policy triggers. And those triggers could be either change in local legislation, change in external legislation, change in vendors. All of these things impact an organization and its policies. But at the heart of dealing with risk is culture. And that culture comes from the top. Without the board directing the culture of an organization, its strategies and objectives will not be met. If you want your organization to be one where the risks are not high, then that is driven by the culture within the organization. So at the very top, the board should know all of the risks that are inherent in their business. They should know all of the risks that are residual. And they should also know how the company is operating. Things like having outdated tools should be brought to the board's attention with a proposal or with a recommendation given at least 3 choices as to replacement and replacement value. The risk appetite should be reviewed. Some organizations do it on an annual basis, especially if you're growing. You have to know how much risk you're willing to take, and you have to be able to mitigate against those risks. Because again, the impact could be you may have a large financial loss that was unforeseen. And whatever risk that you're willing to take, you must have the policies in place. And those policies should have a framework. Because they guide the organization in meeting its goals. For the board to know that it is doing what it should be doing and that the organization's culture is in line with the tone that they are setting, they have to be informed by senior management of what's happening on the ground. So that's not everything. That's what's important for the company to achieve its objectives and its goals. So that means that you do not communicate to the board anything. You have to communicate the right information. And because everything that we write now is risk-based, that means that when you write to the board, you write to the board based upon the risk that the organization faces. In addition to that, you have to be able to look at those risks and report on those risks. Because that's what the discussion is all about, reporting on the risk. And since the board approves all of your policies, they have to know whether or not the controls are effective. The controls are the policies. And the risk department is responsible for identifying where there are gaps. So you see, no matter how small your organization is, you still need to know what are the risks. So if you before the board and you're giving your report, whether it's from operations, whether it's from compliance, whether it's from finance, you should be able to say, these are our risks, these are the likelihood of occurrences, and this is how we intend to address it. And of course, in all organizations, when you look at your objectives, you look at your goals, you look at your financials at that point in time, the organization should be able to say, what if this happens? What if there's a global shortage of this? What if we do not get clients from this jurisdiction? How will that impact our organization? So you're looking at anything that can go wrong. What if our office during a hurricane washes away? What do we do? What is that risk? What's the impact of that risk? How much will that cost us? How much will it cost for us to transfer our employees a week or 3 days before the hurricane from Nassau to New York to Miami? How? How much is it going to cost us? What's the risk? How do we be sure that we have a secure line? How do we ensure that we have all of our clients' data stored in the cloud and it's secure? All of these things are a part of dealing with risk and risk management. Any comments?
This must be your area of specialty because you sure talking stuff that ain't in this book.
I'm explaining it to you.
I like it. I like it.
I do this. Yes, I do this.
I could tell.
I do this. Any questions, comments?
No,
No.
I'm just following and trying to make quick notes.
Oh, you're making quick, but no comments, no questions.
No, I understand.
Okay, all right.
I have one more question. Is risk governance the same thing as corporate governance?
Corporate governance is just a subset of it. Corporate
But
governance.
that's the building block, that's the foundation of it? I thought that's what you said, like the directors.
Yeah, that's what directors, yes.
Okay,
So in any organization, there is a corporate governance. They have different words for it. You can have it like a charter. They don't normally call it a policy, but what it does is it set out the duties and the responsibilities of the board of directors and then senior management. And it also set out whether or not you're going to have any subcommittees. So it really goes around the board and their responsibilities.
okay.
So corporate governance is in some institutions, it's a course all by itself.
Right. I mean, I know that's like not a big buzzword. It's been a buzz term for a while, corporate governance.
Yeah, it still is. It still is.
Yeah, yeah.
Even though they've moved to ESG, it's still
Right.
around corporate governance. They pulled it out
Yeah.
and made it a separate topic, but
Right.
corporate governance is still how you govern, how you run your company.
Yeah.
So, and then corporate governance is also looking at the policies that you develop, the policies that you approve, and the policies that you comply with, because you cannot draft policies and don't comply with those policies.
Right.
And it's looking at your internal and your external stakeholders. So corporate governance is really about not just the responsibilities, but it's about the relationship between internal and external stakeholders, and also looking at the reporting lines. You'd notice that if you are regulated, the first thing they ask you for is an organizational chart. One is organizational chart by ownership, and the other one is by looking at the internal structure, who is reporting to whom, looking for independence. So the stakeholders can be shareholders, employees, investors, persons that provide or companies that provide services to the company. It could be the community at large. But whenever you are in a position as a director, remember from our last class, a director has a fiduciary duty. And that fiduciary duty is a duty of care, skill, and is expected that you would carry out that duty in a professional manner. So anyone who is a director, depends on the industry that they're in, they should be aware of the laws that govern that particular industry. They should be able to understand the responsibilities and the accountabilities in being in that role, sitting around that table. So the mandate of directors and senior management is to be able to identify, measure, monitor, control, and minimize the risk that are apparent to their company. And always is based upon the size of the company. So in order to undergo that risk assessment, in the minds of the board of directors, they should be thinking about what are our products and how are they vulnerable to the various risks, so that they'll be able to raise questions when the presentations is made by the risk department or the risk committee. For the board itself, they must have timely information. Of course, it has to be accurate and it has to be thorough. And they're going to rely on that to make their business decisions. Because you notice in any board meeting, finance takes up the majority of the time at the board meeting. And the decisions that they make in finance is based upon what risk says. Because the likelihood of a risk will impact the financial risk. So for entities that are regulated by the central bank, they have guidelines on corporate governance, and those entities are required to send in a corporate governance certification within 120 days after the year end. And that certification, the board of directors affirms to the regulator. One, that they have policies and procedures in place. Two, that they know their risk. Three, that they have identified gaps or weaknesses. Four, that they are addressing those gaps and deficiencies. They also have to be able to confirm that they have looked at the culture of the organization and they've looked at the control environment of the organization. And so what the regulator does is it places the onus in the rightful place, which is on the board, to give us assurance that the company is being run properly. Now, the company can get an external auditor to review and assess how they would have gone about preparing their corporate governance certification. And of course, the auditors can report directly to the board, but the auditors can also report to the regulators. Any comments? No? So with all of this talk about risk assessment, risk enterprise, the crux of it is a company having a risk appetite, having a risk culture, being able to state that they have policies and procedures in place to mitigate against the risk, that the board is aware of what's happening in the organization, which is corporate governance, that there are policies in place, they are adhering to those policies and procedures in place. One of the key things in the financial sector, including the financial corporate service provider sector, is our duty of confidentiality. And that duty of confidentiality comes from common law and is also in statute. And that duty of confidentiality means that you cannot divulge a customer's information unless it falls under one of the 4 exceptions. One is you have a duty to disclose information if it is under compulsion of law. So that includes filing an SDR or if there is an order from the Attorney General's office, or if you have a matter that comes from the court asking for information. That's under the compulsion of law. The second one is when it's in the public interest. So that means that an institution can disclose information, and normally you would see it where the Securities Commission or the central bank would publish on their website that this person was found operating without a license. So that information would have come either directly from one of his registrants or someone from the public would have advised the regulator that there's someone operating without a license. The third exception is when it's in the bank's own interest, which means the bank has found that there is an issue and it is in their best interest to disclose it. And the fourth one is when you give your express or implied consent. And that's normally done. The express is by contract. So for incorporating a company, that would be in the letter of engagement, or it can be implied. And implied means it arises by common law. So if you have a if your FCSP offers banking services, which means that when a client incorporates a company, if they want to also open a bank account, and you obtain that information from them to open a bank account, on the banking side, they have that duty of confidentiality. You also have that duty, but their duty of confidentiality is a little bit wider than yours because they have more restrictions. And remember that duty that a banker has of confidentiality is similar to those of a director. It is a fiduciary one, which means that the bank can be sued for breach of contract if unauthorized information is given out. Now, under the law, under the Banks and Trust Companies Regulations Act, Section 77, the legislation gives the central bank or in particular, the governor, permission to release information to parent companies for collation purposes. It also permits the regulator to share information with other regulatory bodies. So we all know that our duty of confidentiality in common law and in statute, our preservation of confidentiality is key to our business in the financial arena internationally. Any comments?
Hi, yes.
Is
Dr.
that-
Qu-
Sorry, go ahead, Valencia.
Okay, thanks, Denise, no problem. So in terms of the confidentiality, I understand where you said the central bank can release information, right?
Mhm.
I guess if there's a, I don't know, a lawsuit or something, maybe against a company, that you have to get authority to divulge certain information?
Like, give me a clearer example.
I don't know, if maybe there's a client that has some concern internationally, right? And the authorities are asking for information. And of course, as a bank, I guess you have that confidentiality that you have to maintain. When
They have
does that go
Come to
away?
the general's office.
Okay,
Mhm. Because what the attorney general office will do is to see whether or not it's just a fishing expedition.
oh,
You
okay,
just don't do anything.
okay,
You have to come through the right.
okay.
Now, let's say if someone goes before the court locally, and the court decide that let's say it's a maintenance issue, and the court then says to the father, "We're going to garner your salary."
Mhm.
So that means that the court is going to send an order that whenever that person is paid and their salary hits the account, you have the authority to deduct this sum from that salary and send it to this account.
Okay. Okay.
And then the same way, if in your organization there is, it starts with something unusual, and compliance then determines that it is suspicious.
Mhm.
Because remember, under the Proceeds of Crime Act, it speaks to reasonable doubt. It don't have to be right. It's
Right.
whether or not you have a doubt, and it is reasonable based upon what you see.
Mhm.
By law, you can disclose that to the FIU.
Okay.
If it is something related to theft by an employee, you can disclose that to the police.
Oh. Okay. Okay, thank you.
Denise, you had a comment?
Yes, I was wondering if how this duty of confidentiality applies to personal information as specifically as an FCSP. I know it says there is a duty not to disclose a client's financial affairs, but I know, or previously, I don't know if it's been amended or some other law has overrode it, but like under the Trustee Act, not being able to disclose, a party's identity without their authorization. How does that correlate to corporate administration? So for example, when a related institution is updating KYC or delving into a structure and wants a copy of every related party's KYC documents or IDs, are we able to just provide those copies without first going to the client for their authority to disclose their IDs?
Remember what I said was the fourth exception? What's the fourth exception? When you have the express or the implied consent of the client. So everything.
That would be, that would have to be disclosed in a service, or included in a service agreement. Wouldn't that have to be implicit instead of or sorry, expressed clearly instead of just
expressed.
implied?
Yes.
Hmm.
Mm-hmm.
Mhm.
Because remember now, even the Compliance Commission states that if you, let's say if I'm operating an FCSP and you're operating an FCSP, we may have an internal arrangement between us that you will rely on me to give you confirmation that I have those documents and that if you actually need it for a transaction, I can provide it to you. But in most instances, the Compliance Commission says that each of its registrants must collect their own KYC. So you have the
Definitely.
standing.
Yeah, I guess I mean more instances where, I mean, whether it's an account they've established or, you know, whatever the external relationship is, and a copy of, you know, the client's personal details are required.
That is an
I always wonder if
yeah.
we should, get the client's,
consent.
authorization first to do it.
But what you probably should do is look at your service agreement and see if it needs to be amended.
Yeah.
Because in addition to that confidentiality, and I don't have my FCSP handy, but you have to remember also the Data Protection Act.
Yeah, I saw that.
Yeah. And the data
I mean-
protection, I recall, I think is about, COVID was what, 3 years? So let's say 5 years ago, they were talking about making amendments to the Data Protection Act. So it could be more in line with the EU data protection, giving the data subject more, I guess, more privacy with regard to their information. Because the Data Protection Act really talk about the data controller and how long can they keep your information, that it should be accurate, that you have a right to see it, and that it should be destroyed when it's no longer needed. And just like under the duty of confidentiality, it speaks to who can have access to your information without your authority. So you know by law, anything that's in the interest of the country, they have access to your information. If you're involved in a criminal investigation, they have access to your information. If the government needs to collect taxes like it's doing now, they have access to your information. And that's why you see there's all of this rush by a lot of business owners, because now the government is linking all of the pieces together.
Ever so slowly, though.
Yeah, but they have to understand it as they go and make sure that the legislation is aligned, because the legislation is there but hasn't been enforced. So the Data Protection Act is also there, but more for the data controller and for us as data subject. It's just making sure that the information is not disclosed in a manner inconsistent for which it was gathered. And that it is destroyed when it says it should be destroyed. And then tied to all of this data protection and confidentiality is the provisions they put in the Computer Misuse Act of persons who are unauthorized and then they access the computer to gain information.
I didn't even know that existed, that act.
Yes, it does. And the penalties are stiff. Because the offenses are unauthorized access to computer material, access with the intent to commit or facilitate the commission of a crime, or if you go and you modify computer material, or you try to more or less intercept. They call the persons from, what they call it now, when they hack into your system. If you try to get an unauthorized interception, or you try to obstruct the use of it, or you give someone your access codes. Those are all crimes. And it depends on the damage that is done. You can pay fine and you can go to jail. So those are things that you have to bear in mind when it comes to a client and their information. Now, I could give you an example where a client had investments overseas, and the investment advisor wanted to make a payment, a dividend payment. And in their law, in order for them to release that dividend payment, they had to have the KYC of those clients. Otherwise, it could not be paid. And on first instance, the information was not given. And on second instance, the information had to be given because it was one company speaking to another company, asking for the information on the company itself and who would benefit once the funds were distributed. Now remember, a lot of these questions are tied into taxation. Because taxation is the key to everything. So I wanted to look at two cases, not in full, but I can send them to you all and you can lay down and read it at your leisure. One is 34 pages long. It is a Bahamian case, don't die. And the next one, stop. No, not you, phone. And the next one is a Supreme Court case from the UK. And that one is 37 pages long. Here's what I found. Oh, Lord. This phone is talking. This watch.
Thanks so much for those little presents, by the way.
Okay, so the first one, the Bahamian case, is in the matter of FinEthic Limited. And it was a winding up petition. They had joint liquidators also. And included in this was the registered agent and the director. Let me see if I can find that page. Just on the director. I should have put a ban in it. Oh. Right here. So this is an application by FinEthic Limited. It's an IBC. Mr. Paul Moss is the sole director of the company. And Dominion Management Services is the registered agent. So they are the applicants in this matter, and they're asking for an order to be set aside, appointing joint provisional liquidators of the company. So The background was FinEthic was incorporated as an IBC on the 18th of February, 2004. The registered agent is Dominion Management Services Limited. The authorized capital is $5,000 divided into 5,000 shares of $1 each. The registered members of the company are the petitioners, Mr. G. Nembry and his brother, Mr. A. Nembry, and they hold 2,500 shares each. So since April 2017, the president of the company has been Mr. Paul Moss and the secretary, Ms. Melanie Lightbourne. The question arises as to the validity of the 2017 appointments of officers as well as the registered office and agent. So let me see what the brothers said. The petition recites that the company has been in gridlock since about 2015. The members have been unable to reach agreement on any fundamental issue concerning the management and direction of the company. Owing to this paralysis, the then appointed directors, Gina A. Martinez and Fernanda A. Gill, tendered their resignations on the 12th of December, 2016, with immediate effect. And the then registered agent, Aliman, Cordero, Galindo, and Lee, Bahamas Limited, also by letter dated December 2016, resigned with 90 days notice. The members were apparently unable to agree replacements for their resignations. So by a virtue of a written resolution, apparently passed solely by Mr. A. Nembry on the 20th of April, 2017, the current registered agent, registered office, and president of record for the company were appointed. The secretary was appointed by a separate director's resolution of the same date. The petitioner alleges this was done without consulting him and that he does not consent to these appointments. So on the 21st of August, 2020, Mr. G. Nembry presented a petition to wind up the company in accordance with Section 89 of the IBC Act and Section 186C of the company's Winding Up Amendment Act on the ground that it was just and equitable to do so due to gridlock. So the issue was whether or not the petitioner lacks the requisite standing under the act to present the petition. The petitioner is not a creditor, nor claims to be a contributory, and cannot make out a prima facie case for the appointment of a professional liquidator in accordance with Section 199, subsection 1 and 2 of the Act. So the issue is, one of the issues was whether Mr. Moss has standing, having regard to the challenge to his appointment and the subsequent appointment of provisional liquidators to advance the application and swear affidavits on behalf of the company or its directors and agent, and if not, whether such affidavits should be struck out. So this is what the court said. Logically, I will deal with this matter first, because if I were to determine that Mr. Moss or Dominion has no standing, that would effectively be the end of the application. The petitioner advances the lack of standing claim primarily on what is said to be the impropriety in the appointment of the current officers. But there is naturally also the consideration of the appointment of the joint provisional liquidators on any authority they might have held. The circumstances in which the current applicants have been appointed have been adverted to and are summarized at paragraphs 13 through 15 of the petition. Quote, upon the resignation set out in paragraphs 10 to 12 above, the members were unable to agree upon replacements. By virtue of a purported written resolution, purportedly passed solely by Mr. A. Nembry on the 20th of April, 2017, the current registered agent, registered office, president, and secretary of record for the company were appointed. This is notwithstanding the fact that pursuant to Article 22 of the company's Articles of Association, more than 50% of the members are required to convene a meeting. 2, Article 25 of the company's articles requires a quorum of 51% of the members. And 3, pursuant to Articles 36 of the company's Articles of Association, a resolution must be approved by more than 50% of the members. The petitioner was not consulted with respect to and does not consent to the appointment of the current registered agent, registered office, director, and secretary. So in answer to the challenges to the appointments, Mr. Morse, in his third affidavit, produced the company's register of directors, filed with the company's registry electronically on the 30th of November, 2017. That records Mr. Paul D. Morse and Ms. Melanie Lightburn, respectively, as the current president and secretary of the company, having been appointed with effect from the 20th of April, 2017. The applicant contends that this is prima facie evidence as to his appointment as director of the company. Further, he contends that the petitioner has not put any contrary evidence before the court, nor sought to challenge his status as a director through any lawful means available to him. So in addition, the applicants rely on the statement of Judge Plowman in the case of Reunion Accident Insurance Company Limited to argue that the appointment of a provisional liquidator does not rob a director of certain residual powers, which includes the power to challenge a petition for winding up. The respondent's, quote, the respondent's submission was that the appointment of a provisional liquidator automatically puts an end to the authority of a company's directors to instruct solicitors and counsel to represent it, and that the solicitors purporting to act on its behalf were therefore liable to pay the respondent's costs personally. It is, of course, well settled that on a winding up, the board of directors of a company becomes functus officio, and its powers are assumed by the liquidator. And my attention was drawn to Re-Morcon Limited, where Judge Pennyquick said that in effect, the appointment of a provisional liquidator had the same effect. No doubt that is so, but it is common ground that notwithstanding the appointment of a provisional liquidator, the board has some residuary power. For example, it can unquestionably instruct solicitors and counsel to oppose the current petition, and if a winding up order is made, to appeal against that order. Considering the circumstances of this case, it seems to me that while there may be grounds on which the petitioner might properly challenge the status of the company's officers, registered office and agent, the persons and/or entities indicated on the statutorily required records of the company are prima facie the current office holders and/or service providers. In fact, maintaining a registered office and agent are mandatory requirements of an IBC under the IBC Act. Therefore, until a proper application is made to challenge these appointments, the court is constrained to accept that Mr. Morse is a director and therefore entitled to make the application. In fact, the petitioner tactically concedes this in the petition, in which it states that, quote, the president of the company since the 20th day of April 2017 is Paul D. Morse, although the petitioner disputes whether the appointment of Mr. Morse was valid. So as pointed out by the Privy Council in Archer and another versus Registrar General and another, a judicial review appeal relating to the rectification of the register of members of a company, any dispute as to its correctness, that is the register, is to be resolved by the court either on a summary application under Section 57 or in a complex case raising factual dispute in other proceedings. While that dispute was about the register of members under section 57, the point is that the petitioner could always have approached the court for declaratory or injunctive relief in respect of the companies. Any comments?
Yes, ma'am.
Yeah,
I thought it was interesting, the point that was made that the petitioner, I think, in his application indicated that Paul Moss was the director.
yeah, he
Or
was.
is, sorry, is a director.
Yeah.
Oh, so does that weigh on the ruling that he did admit, or did I get, I mean, I guess I got a bit confused there too, because he said, okay, he is a director, which he was, unless I'm wrong, he was a director, but he was, the petitioner was not in agreement with him being appointed.
Yeah, because it's two brothers.
Right,
One
right,
brother,
only one, yeah.
brother, right. One brother went ahead and made all the decisions. So
right,
the other brother is saying that it's not valid.
right, which is correct, I would think, because it said it needed more than 50% of the members.
Yes. But what the
Right,
court
so-
is saying that is something that they should have brought before the court
Oh, okay, they didn't do that.
on a
Okay,
separate matter.
I see. Oh, wow.
That's
Okay.
a matter that goes before the court with the registrar general.
Okay, then you can't just say, oh, I disagree with you being the director. Okay.
Exactly.
Wow.
Yes. You have to
Okay.
bring that before the court
Okay.
because I think I have the case they referred to, Archer on another. Remember I referred to that case?
Yes, I heard that.
Yeah, close to the end. Let me see if I have it handy. Okay. Hopefully, well, this one isn't long. It's 11 pages long. But I don't know if I could ever find it. This is in 2004. And this matter raised the issue as to the functions and duties of the Registrar General under the legislation relating to the registration and regulation of companies in the Bahamas. So it says that this limited point arises against a background of events which are complicated, obscure, and controversial, spanning a period of 20 years. I could send it to you because I haven't highlighted the key paragraphs. Well, I don't know if you'll be able to see it though. I'll have to go through this. But I did mention the part that when he referred to the case. Go back to slow.
So this case, were they not suing, but I guess having a complaint against the Registrar General's Department? Is that what that means?
No, that's what he's saying, because he's saying that Moss appointment,
Mhm.
he didn't accept that. That's a matter that he should have taken to the court against the Registrar General.
Oh, for accepting him as director?
Yes,
Oh,
because don't forget now, even though the article stated the requirement, they still went ahead and made him director.
so they should have come back and disputed it, or said, okay, this is not in line with the articles. Is their responsibility to do that? Is that-
Yeah, he did. Yes, the other brother could have taken that route first.
Oh, okay, but I mean, it wasn't the registrar, because I guess they're just filing the documents they get?
So what they're doing is, Paul Moss, they are saying that they don't want the winding up to be done because
Right,
one of the brothers wants it wound up because the two brothers can't see eye to eye.
right.
So the first point that's being raised by the brother is that Paul Moss and this Liburn woman are not,
Direct and
they were not
secretary.
duly appointed according to
Okay.
the articles.
Mhm.
So what the judge is saying is that is a matter that should have been taken before the court bring in the registrar as the person who has the answer.
Oh. The registrar.
The
Oh,
winding up petition and the provisional liquidator comes before the Supreme Court proper.
okay.
But the question is whether or not the appointment of Mr. Moss and Lightburn, are they really appointed by
Okay.
law?
Okay. So,
You see?
yes. So had they, I guess, done the appointment to the court, had the brother taken it up with the court, it was for the registrar to say.
Uh-huh.
who- Okay. I guess
The registrar will say what the process was, whatever the
Okay.
law requires, and then the
Okay.
judge would have given an order. So that's why the judge said, because if I were determined that Mr. Moss or Dominion had no standing, which means that they were not duly appointed, he say, then the application is over. But because that matter wasn't put before a judge, making the registrar general to answer to whether or not what he did was legal,
Okay.
he says, let's go ahead.
Okay, I understand.
I think the registrar general comes into it though with appointment of the registered agent, because if I recall, you said that in 2016, the original registered agent resigned, and
Yes.
the process for that is the registrar general has to be notified of that resignation, and within 90 days, if there is not a subsequent registered agent appointed to that company, there's a notice published in the Gazette, and then that company, after I think 30 days or something, if still nobody comes forward to appoint a registered agent, that company is supposed to be struck off the register. So I think that is where the registrar general would have to, speak about what happened there.
Yeah. Because when you look at it, the letter was dated the 12th of December, 2016. The resolution passed by the brother for the Dominion and Moss was done on the 20th of April, 2017.
Right. I thought I had calculated more than 3 months.
Yes. Yes.
So in actuality, that company should have already been struck off the register.
This is past the time. Yes. But it's a very long case and the writing is very fine. So if you're interested, I can send you that one. I know y'all don't like these long things.
So, Ms. Archer, sorry, even Denise's point about it should have been struck off. Could the court have said that? Could they have said? Okay.
No, after he made that decision right there, he went into looking up at the winding up order.
Right. Oh boy. Okay. You could have said, okay.
Yeah. And then hold on, let me see what he said at the very end. See if we do. Because everything turned on this affidavit. The decision was on the affidavit that was submitted after the filing of the petition. So that's where this case turned on. And let me see what he says here. In the circumstances of this case and for the reasons given, I order that the ex parte order made on the 20th appointing the joint provisional liquidators be set aside. I find that the varying affidavit is ineffectual for non-compliance with the acts and the rules. I stay all other further proceedings pending the hearing of the application to have it struck out. Yeah, but this had to do with the provisional liquidator's appointment.
And Valencia, just to clarify, or for my purposes too, the Registrar General, no, I mean, when you submit a register of directors and officers, they just accept that and put that in the file. They do no verification at all, because they do not have a copy of the resolution appointing. You're not required to submit a resolution appointing or resigning directors. So they really have no way to verify if it was properly, if the directors were properly appointed.
No.
Okay. So should that then become a requirement to like have to submit the resolution too? I don't know who does all these checks.
Nobody
But-
does those checks, so no.
But if the matter is brought to the court, yes, then they would ask for all of those documentation.
Yes, but it wouldn't be incumbent on the registrar. It would be
No,
incumbent on the
no.
company to
Yes. Dominion would be the one who
verify.
loved to show, right? Dominion loved to show
Right.
that they followed all of the steps and they met all of the required deadlines.
Okay. Thank you both.
But
Thank
the
you both.
registrar would have to they are responsible for ensuring that a registered agent is properly appointed.
Okay.
Yes.
Thank you. Thank you both.
Okay. So let me go to this next case that I know Denise is waiting for me to send to her. She's excited. Truly excited.
Indeed. I cannot wait, can I tell you?
So this one is called Vedanta Resources, VEDANTA, versus Longowi and others.
Just to
And-
backtrack for 1 second, sorry.
Go ahead.
I was trying to find when you were speaking that thin ethic. Was that THINETHIC?
No, F as in frog, INETHIC Limited, spelled out.
F. Oh,
The name on it is kind of long. So it says, in the matter of the IBC Act, and in the matter of FinEthic Limited, and in the matter of a winding up petition filed in relation to the said FinEthic Limited pursuant to Section 190 of the Winding Up Act, and in the matter of an order appointing joint provisional liquidators of the said FinEthic Limited, and in the matter of the applications of FinEthic Limited, Paul D. Morse, and Dominion Management Services Limited.
gosh. I think the reason I couldn't put it up is because I thought you were saying thin, like THIN.
No,
So
no,
that's
it's-
fine. All right,
Yeah,
great,
frog.
thanks.
Yeah. So I can send it to you. I'll send it to you. Y'all could have it to read with your coffee tomorrow.
Thanks, I
Ved-
get heartburn.
Vedanta versus Longowi. So this litigation arises from alleged toxic emissions from the Nachanga copper mine in the Shangola district of Zambia. So the claimants, who are the respondents in this case to this appeal, they are a group consisting of some 1,826 Zambian citizens who live in 4 communities within the Chingola district. They are very poor members of a rural farming community served by water courses, which provide their only source of water for drinking. And that's drinking for them and their livestock. And is also for irrigation of their plants. They say that both their health and their farming activities are being damaged by repeated discharges of toxic matter from the Changa copper mine into their water courses from 2005 to 2019. The Changa copper mine consists of an open cast mine. It's said to be the 2nd largest mine in the world and in part of a deep mine. Its immediate owner is the Second Defender, a company called KCM. And KCM is a public company incorporated in Zambia. KCM is the largest private employer in Zambia. It employs 16,000 people, and most of them work in the mine. The first defendant is Vedanta Resources. And Vedanta Resources is the ultimate parent company of KCM. So remember what I said, the matter is Vedanta, who is appealing, versus Longowi, the claimants. So the first defendant, Vedanta, is the ultimate parent company of KCM. It is the parent of a multinational group listed on the London Stock Exchange. And it has interest in minerals, power, oil, and gas in 4 continents. Vedanta is incorporated and domiciled in the UK. So although Vedanta claims only to have 19 employees of its own, 8 of them are its directors, the Vedanta Group employs 82,000 people worldwide. KCM is not a 100% subsidiary of Vedanta because the Zambian government has a minority stake. But materials published by Vedanta state that its ultimate control of KCM is not thereby to be regarded as any less than it would be if wholly owned. You understood that so far? Everybody has the structure?
I think so.
Yeah, okay. I thought Valencia was saying something just now.
Yeah, I think I was following.
Okay, all right. So the claim is against both defendants. It's against KCM and Vedanta. And what they're pleading is common law negligence and breach of statutory duty. So the causes of action are pursued against KCM on the basis that it is the operator of the mine. As against Vedanta, the same causes of actions are said to arise by reason of the very high level of control and direction that the first defendant exercised at all times over the mining operation of the second defendant and its compliance with applicable health, safety, and environmental standards. The appeal is all about jurisdiction. That is, the jurisdiction of the courts of England and Wales to determine those claims against both defendants. And as against Vedanta, the claimants rely upon Article 4 of the recast Brussels Regulations 1215/2012 on jurisdiction and the recognition and enforcement of judgments in civil and commercial matters. As against KCM, the claimants rely upon what may loosely be called the necessary or proper party, gateway of the English Procedural Code for permitting service of proceedings. So now let me go to Vedanta or Vedanta, the defendant domicile will be referred to here in England is referred to as the anchor defendant. And the defendant domicile abroad will be referred to as the foreign defendant. So the jurisdiction against the anchor defendant derives directly from Article 4.1 of the Brussels Regulation. And that provides that subject to this regulation, persons domiciled in a member state shall, with whatever their nationality, be sued in the courts of that member state. The basic provision is designed not only for the protection of EU domiciliaries, but also to enable a claimant to know with reasonable certainty where he may sue The second is Vedanta. They maintain that even if the pleaded claim discloses a tribal issue against it, nonetheless, the claim should be stayed as an abuse of the EU law, because the claimants are using a claim against Vedanta in England purely as a vehicle for attracting English jurisdiction against their real target defendant, KCM, by means of the necessary or proper party gateway. Now, the judge, in the first instance, rejected that submission. And the Court of Appeal, they are pursuing here with the requisite permission of the court to look at the EU law and see whether or not it's relevant. So without going through how many pages, 1, 2, 3, 4, 5, 6, 7, 8, 9. The judge said after 9 pages that they resolved that the abuse of the EU law issue in favor of the claimants without any need for reference to the Court of Justice. So he allowed them to go ahead and proceed. So he said, what's the real issue to be tried as against Vedanta? He said the extent to which the absence of disclosure of defendants' documents may impede claimants in demonstrating a tribal issue depends, of course, upon what are said to be the defects in this case. In the present case, the critical question is whether Vedanta sufficiently intervened in the management of the mine owned by its subsidiaries, KCM, to have incurred itself, rather by vicarious liability, a common law duty of care to the claimants. A fault-based liability legislation in connection with the escapes of toxic materials from the mine alleged to have caused the relevant harm. The level of intervention in the management of the mine requisite to give rise to a duty of care upon Vedanta to persons living, farming, and working in the vicinity is, as is agreed, a matter of Zambian law. But the question whether that level of intervention occurred in the present case is a pure question of fact. I make no apology for having suggested during argument that it is blindly obvious that the proof of that particular pudding would depend heavily upon the contents of documents internal to each of the defendant companies and upon correspondence and other documents passing between them, currently unavailable to the claimants, but in due course disclosable. So he went on to say, but the liability of parent companies in relation to the activities of their subsidiaries is not of itself a distinct category of liability in common law negligence. Direct or indirect ownership by one company of all or a majority of the shares of another company may in
Hello, I can't hear.
I can't hear it either. It just went blank.
Neither can I.
Oh, okay.
I think she got disconnected.
Pass over.
Hi, it dropped. Where did it drop?
2 minutes ago is where it dropped.
Dropped when I started talking about the liability of parent companies.
Correct.
I think
Yes,
so,
okay.
yeah.
Yeah, okay. So the liability of parent companies in relation to the activities of their subsidiaries is not of itself a distinct category of liability in common law negligence. Direct or indirect ownership by one company of all or majority of the shares of another company may enable the parent to take control of the management of the operations of the business or of land owned by the subsidiary, but it does not impose any duty upon anyone else. Everything depends on the extent to which and the way in which the parent availed itself of the opportunity to take over, intervene in, control, supervise, or advise the management of the relevant operations of the subsidiary. All that the existence of a parent-subsidiary relationship demonstrates is that the parent had such an opportunity. So he then refers to the case of AAA versus Unilever PLC. And in that case, it stated that there is no special doctrine in law of tort of legal responsibility on the part of a parent company in relation to the activities of its subsidiaries, vis-a-vis persons affected by those activities. Parent and subsidiary are separate legal persons, each with responsibility for their own separate activities. A parent company will only be found to be subject to a duty of care in relation to the activities of a subsidiary if ordinary general principles of the law of tort regarding the imposition of a duty of care on the part of the parent in favor of a claimant are satisfied in the particular case. The legal principles are the same as would apply in relation to the question whether any third party, such as a consultant giving advice to the subsidiary, was subject to a duty of care in tort or to a claimant dealing with the subsidiary. Helpful guidance as to relevant considerations was given in the case of Chandler versus Cape PLC. But that case did not lay down a separate test, distinct from general principle, for the imposition of a duty of care in relation to a parent company. So although the legal principles are the same, it may be that on the facts of a particular case, a parent company having greater scope to intervene in the affairs of its subsidiary than another third party might have, has taken action of a kind which is capable of meeting the relevant test for imposition of a duty of care in respect of the parent. So he went on further to say there is no limit to the models of management and control which may be put in place within a multinational group of companies. On one end, the parent may be no more than a passive investor in separate businesses carried out by its various direct and indirect subsidiaries. At the other extreme, the parent may carry out a thoroughgoing vertical reorganization of the group's business so that they are, in management terms, carried on as if they were a single commercial undertaking, with boundaries of legal personality and ownership within the group becoming irrelevant until the onset of insolvency, as happened in the Lehman Brothers Group. He said the general principle that a parent could never incur a duty of care in respect of the activities of a particular subsidiary merely by laying down group-wide policies and guidelines and expecting the management of each subsidiary to comply with them. This is, he submitted, all that the evidence has thus far
Anybody can hear me?
No,
Excellent. I know I was making sure that I wasn't blank out.
Mhm.
but we
No.
can't hear Miss Archer.
Right, she probably dropped again.
She must be got alive.
Girl, alive is good, girl. You talking about
I'm BTC all the way.
it's a sign because I need to take a nap.
Same. Same.
I was taking a nap listening to her read.
I can confirm nor deny.
Okay, it's back on.
Your last word was thus far. That's the last thing we heard.
Oh, I don't know why this is dropping. Okay, hold
It's
on.
a
very-
sign.
No, it's not. Okay, it's the sign, then you can read it. But let me tell you what happened in the end. In the end, Vendetta then tried to challenge the court by saying that the court was not taking into consideration local cases. So it went to, it referred to this case, the Nasulu case, where there was 2,000 claimants and they were injured in a mine. But only 12 of them had brought evidence in the case. And so the trial judge found in favor of the claimants on liability. And they were content to award general damages to the 2,000. And on the basis of them. And so they tried to bring that matter before the Supreme Court, saying that they should really take into consideration the local cases. And then another case they referred to is in the case of Shamaleo versus Nitrogen, Chemicals of Zambia. And that was about radiation emissions. And there was evidence which entitled the judge to find, as he did, that this claim failed on causation because the claimants could not fund the necessary expert evidence to prove it. So the judge in this matter said, he reject the appeal case on the abuse of EU law and real tribal issue. And having upheld their case on proper place, I would, but for their failure on the issue as to substantial justice, have been minded to allow their appeal. As it is, however, that this appeal should be dismissed on a substantial justice issue. So the claimants in this matter won the case.
Yay.
They actually did. And now, before my thing drop again, if you all are interested, I found my case that I wanted to talk about. I think I mentioned it 2 or 3 classes ago. Oh, where's my other one? Remember at the very beginning when we talk about piercing the corporate veil?
Yes.
And I told you all there is a Bahamian case, not going through the case of Press versus Petrodel, but it mentions it. And that case was the case of Julius Chisholm and Ophelia Chisholm. You heard of that case?
No, but I went to
No,
school with
ma'am.
Michelle Chisholm.
So the parties were married in 1998. The husband was a widower and the wife was a divorcee. Days before the marriage, the husband transferred his assets to a company beneficially owned by him and his children by his deceased wife. At the time of their marriage, they were 56 and 47 years old, and they were married for 19 years until a petition for dissolution was made by the husband. The decree nisi was granted in June 2018, and ancillary proceedings commenced. The judge gave his written rulings in September 2020. The husband appeals the decision of the
Testing 1, 2.
I think she dropped it. Oh, here comes. She's back.
You know what I believe is you all. Y'all trying to jinx me.
No, ma'am, but the last thing you said was
No way.
either the year 2000 or the year 2002, one of them.
All right.
Okay. Oh, that was Colley versus Colley in 2012.
Okay.
Okay. So in this case, in the Court of Appeal, the appeal was dismissed. Save for that part of the order relating to the jewelry, the order of Thompson J is confirmed. As the husband has not been successful in this appeal, save for the order relating to the jewelry, the proper order is that the husband pays 85% of the wife cost to be taxed if not agreed.
I think
So,
we missed. I don't think we got.
Yeah, we missed a whole bunch.
Yeah, we missed-
The
yeah, we
last thing
didn't
you
get-
said
yeah.
was that they made the ruling in
What you
2000 or
missed?
2002.
Yeah,
the
we
last thing you
didn't-
said.
that's just a case. That's just a case.
I thought we was talking about the case with the husband and wife and deceased and
Yes,
all
that's
that.
it. Yeah,
But I feel
said-
like you missed out all kinds of things.
Yeah, we missed out a lot.
Oh.
Sorry, we didn't hear a lot.
Yeah, the
Okay.
last thing I heard was you saying, I think the case, they made a ruling in 2000 or 2002.
I have the decree June 2018.
I hear that part too, but then I hear after that she going to like
Okay.
2000, 2002.
The decree Nisai was granted in June 2018, and ancillary proceedings were commenced. The judge gave his written rulings in September 2020, and the husband is now appealing the decision of the judge concerning the division of the property belonging to the parties of the marriage. And he is saying that the judge erred in law, and in his application, he didn't like the way the treatment that he used. He said that the application should have been fairness and equality based on the principles in Colley versus Colley, 2012. That's the year of that case. And the judge dismissed his appeal. And the judge said the entire object of the division of property upon the dissolution of a marriage is to achieve fairness. It is not the law that assets acquired before marriage are irrelevant to determining fairness. As the judge appears to accept it that the assets acquired before marriage and transferred to a company owned by the husband and his children before marriage were used for the benefit of the husband and wife during the 20 years of their marriage, he is entitled to take them into account in determining what is a fair division of assets. The fact that the husband may have only a limited legal right to the income from those assets acquired before marriage and transferred to a company beneficially owned by him and his children before this marriage does not prevent the court from taking them into account and determining fairness. If the court credibly believes that the husband could reasonably expect to receive some benefit from those assets, that is the fact the court is entitled to take into account. So you see what he did, right? At the beginning. They were married in 1988. And days before the marriage, he transferred his assets to a company. And then he put the ownership of the company in his name and his children. The children from a previous marriage, so that she wouldn't have access to those assets. But the judge in this divorce case took that into consideration. So he didn't pierce the corporate veil. He went around that instead and had him state all of his assets. So he said, in the result, I understand what the judge was trying to achieve. He took account of assets acquired before the marriage to assist in determining what income was available to the parties in order for them to live in the twilight of their years. He found that the wife was wholly dependent on the income from the lodge, but that the husband had available to him other assets, which would generate income to enable him to live. It must be recalled that the court must address the needs of the parties before determining the division of assets. Because what he tried to do is the assets that were in the company, for the wife not to have access to those companies, to those assets, even though she assisted him during the marriage with those assets in that company.
Wow.
He gave her jewelry and he wanted to take the jewelry also.
Yeah. How did she assist? By what? She worked in the company or?
Yeah, she worked in the company.
Ah.
Let me see if I can find it in here. It's kind of long, but this is a good one. Let's see what he did. What she did in her petition. The wife said, we were married on 20th of December and he was 56 and she was 47. During the almost 20 years of our marriage, I sacrificed my career to be a dutiful wife to the petitioner, who was and is not only a building contractor, but a pastor as well. Throughout our marriage, I worked at the petitioner's side in our church, Pilgrim Native Baptist Church in Acklands. As his wife, I literally wrote about 99% of all the sermons delivered by the petitioner. I organized and hosted all his church meetings. In fact, I was his executive secretary and the organist in the church. At home, I kept our home, was washed and ironed my husband's clothes, cooked 3 meals per day for him. Further, whenever he was on a construction job, I not only cooked and hand-delivered his lunch, but I did so for his workers as well. Throughout the marriage, as a Christian and pastor's wife, I submitted my body, my talents in music and finance, together with all my savings and resources, to my husband for the benefit of our family, believing the petitioner's promise to always and spiritually.
I wonder why they divorced.
Because he could kill.
Mm.
Because how you so pastor, you're trying to hide the money from a couple of days before.
That's what I'm saying. Wow.
He's a whole pastor, you're trying to hide the money from days before. You can kill from a long time.
She got
Oh.
tired of being his dutiful servant, must be. She got
I mean,
sense, finally
she
got
wrote-
sense.
She wrote all the sermons
That's how it is be.
and he trying
I
to
know,
swing her.
I know you all would like this one.
Yeah,
Anyhow,
interesting.
so the wife lists the assets she says are owned by her husband. She said, I have read the petitioner's affidavit filed herein on the 16th of July, 2018, and say that the petitioner has not disclosed to this honorable court his means and/or assets. I am aware of the following assets. A, 8 to 12 acres of land on the island of Andros, of which the petitioner sold 3 to 4 lots during the marriage. B, duplex situated number 9, Hampton Avenue, South Beach, comprising units 1, 2-bedroom, 2-bath, and unit 2, 2-bedroom, 1-bath, value $300,000. I'm talking fast in case the internet drop. C, Vacant lot adjacent to South Beach duplex, valued about $65,000. Property, 4th Street, The Grove, to which is a pertinent 4-unit apartment complex. Units rented at $600 per month and 1 unit rented at $1,000 per month. Parcel of land, Chester's Bay, Acklands, vacant. J&J Chisholm Construction Company, a construction company. The petitioner and I own jointly in Chester's Bay, Acklands, a parcel of land on which the business Chester's Highway Inn Bonefish Lodge. We further own 2 fishing boats. Andrews Properties, the petitioner, I verily believe, acquired these properties prior to our marriage. I am unaware as to the value. South Beach duplex. When the petitioner and I got married, we agreed that we would live in the then house in South Beach. However, my suggestion, we converted the house to a duplex with the intent that unit 1 would serve as our matrimonial home while we rented unit 2 for additional income. To convert and renovate, the petitioner and I pooled our resources. At that time, I had some $30,000 on fixed deposit at First Home Savings and Loan British American Bank, Marquis Street branch, left to me by my deceased relative. I expended my entire $30,000 on new cabinets, bathroom fixtures, tiles, draperies, furniture, driveway on the South Beach home. I verily believe that the petitioner and his adult children now reside in unit number 1 to my total exclusion, despite my having expended my entire inheritance, preparing the unit to be our matrimonial home. Unit 2 of the duplex is rented for $800 per month. Number 17 is an adjacent vacant property. This property is currently being used by the petitioner and or his adult children for the construction company vehicles. The property also has a shed on it, which is used to store construction equipment, value $65,000. Property situated 4th Street, The Grove. Property is an apartment building with 3 apartment units. He received rental income of $600 each, $800 per month. Another portion of the building was used by the petitioner during the marriage as the office for his construction company. The office space is now rented at $1,000 per month. The market value of this property is $400,000. J&J Chisholm Construction Limited, the petitioner was and is a building contractor. When the petitioner and I married, he insisted that I give up my career as a music teacher to work with him and the construction company. At the time, I was teaching music and playing the organ at the following institution: Prince William Baptist High School, where I earned $800 per month; Bahamas Baptist School of Music, $500 per month; Queens College at $2,353 per month; Bethel Baptist Church at $700 per month. In total, I was earning from my music career $5,353 per month. I gave up my career and income therefrom on the petitioner's promise that working together, we would build a life together, and he would always provide for me and love and cherish me.
You better try hard, run that woman her money.
Hook, line, and sinker, boy.
Because
Wow.
I ready to fight him now.
So now they're divorcing. They are 70 years old.
Oh, wow. Oh, wow.
Wow.
She, in her affidavit, she said, I am diabetic. I was paralyzed in or about 2008. For my paralysis, I underwent major back surgery, accruing substantial medical expenses, which continues to date as I am in constant need of physical therapy. I further suffer major complications with my sight, consequence on the diabetes. I'm restricted to a special diet and costly medications, including 3 insulin shots every day for the rest of my life. I have no medical insurance.
All that money they were earning and no medical insurance. Jeez, some crime.
No,
People getting divorced at 70?
That's what I'm trying to.
they actually did. This is a
Are they
local
funny?
case. See, if this was
Wow.
foreign case, I can hear you all, Karen. This is a local one. Just
But people at 70? Stay
Yeah.
together?
But you said
Not.
he appealed something? He appealed, you said he appealed the ruling, I guess, for. what-
Yeah,
what's the ruling?
he appealed the decision.
Where are they
Okay,
now? Like,
so this is the order that was made by the judge. This is what he's appealing. It is hereby ordered that the petition do forthwith transfer to the respondent all his right, title, and interest in and property to Chester's Bay Acklands, together with the business Chester's Highway Inn Bonefish Lodge. And upon such transfer, the respondent should be responsible for satisfying the balance of the loan at the Bahamas Development Bank. The petitioner shall, within 90 days of the date hereof, pay to the respondent a lump sum of $8,000 to assist the respondent with the purchase of a car. The petitioner shall, within 30 days of the date hereon, return to the respondent the 3-rode all diamond wedding band, 3 slave bands gold, 2-foot-long gold rope chain with a large conch shell nugget diamond chain, a 1971 Independence mounted gold coin ring, a 3-diamond stone ring, and garnet studded earrings, failing which the petitioner shall within 20 days thereafter pay to the respondent a lump sum of $15,000, representing 1/2 of the value of the said jewelry. So he took the jewelry too. Within 30 days of this order, the respondent shall procure 3 quotes from reputable registered contractors on the island of Auckland, and the lowest quote is to be accepted for the repairs. Such quote not to exceed the sum of $25,000 to be paid to the petitioner. The respondent shall forthwith transfer to the petitioner all her right, title, and interest in the following properties: the 8 to 12 acres of land in Andros, the duplex in Hampton Avenue, South Beach, the vacant lot in South Beach duplex, the property on 4th Street, the parcel of land in Chester Bay, Auckland, J&J Chisholm Construction. The respondent execute a renunciation of dower to the petitioner of 5% retention interest in the various assets of the petitioner, and each party shall bear their own costs. So he appealed on the ground that the learned judge erred in fact and law, and that there was failure to properly apply the established equality principle, that there was failure to identify and provide reasons why there was a deviation from the equality principle, and or there was unreasonable consideration of facts and properties that were not matrimonial assets. That there was a failure in not finding that the property situated on Chester's Bay, Auckland, along with the accompanying fishing vessel, were the only matrimonial assets. And there was failure in not finding that the property situated on Chester's Bay, Auckland, served part of the matrimonial home. So he went on and he was appealing everything that was awarded to her.
So she in fact had to turn around and get rid of everything she had? Is that what the appeal, that was the final appeal or the final ruling?
No, in the final appeal and decision, the judge says, in the absence of
Got
full,
the lodge.
huh? So he said what?
Oh, only thing I remember you saying she got was the lodge. Like, who wants
Yes.
that?
So he said, in the absence of full and frank disclosure by the husband, he cannot now be heard to complain. I agree with Sir Michael that in the circumstances, the exercise of the learned judge's discretion cannot be faulted. It appears from the perfected order, the learned judge ordered the husband to transfer to the wife his interest in the property situated at Chester Bay, Auckland, which they had acquired during the marriage together with the Chester's Highway Inn and Bonefish Lodge business. He further ordered the wife to transfer to the husband all her right, title, and interest in several properties, including the J&J Chisholm Construction Limited. It is evident that what the learned judge was essentially doing was making property adjustments on a clean break basis to ensure that the wife's future needs were met from an income earning asset, which had been acquired during the marriage. The property adjustment orders were also made in recognition of the contributions which the wife claimed to have made during the marriage. A, to the renovation and conversion of the South Beach property. B, by giving up her employment as a music teacher to work alongside her husband in his construction company. Accordingly, as part of the clean break and in the exercise of his discretion, the learned judge ordered the wife to transfer to the husband all her right, title, and interest in several properties, including the J&J Chisholm Construction. The order covered in particular the residential property situated at number 9 Hampton Avenue, South Beach, held by a property holding company, which had at one time served as the couple's matrimonial home. In making both property adjustment orders, the learned judge clearly took into account the uncontroverted affidavit evidence of the wife that the South Beach property had been renovated and converted into a duplex during the marriage using a financial contribution of $30,000, which the wife had made from her personal resources. Again, in the perfected order, The learned judge further ordered that the husband make a lump sum payment to the wife of $8,000 toward the purchase of a car, and a further lump sum of $25,000 to assist the wife to renovate and repair the Chester Bay Acklands property. What the learned judge was clearly doing was making a number of financial provision orders geared at meeting the wife's transportation needs in Nassau and ensuring that the wife was placed in a position to continue to generate an income in the future from the Chester's Highway Inn and Bonefish Lodge business, which was shown to be in need of repair and renovation. I'm satisfied that having assessed the parties' respective financial positions on the affidavit evidence before him and found that the husband was in a better financial state than the wife, the judge was entitled to make the 2 property adjustment orders and the various financial provision orders, which he ultimately made. In the absence of full and frank disclosure as to the husband means, the learned judge was entitled to assume that the husband received an income from the many income earning properties he had transferred to the property holding company, in which he still retains a 5% interest. He gave the rest of the interest to the children when he set up the company. I therefore agree with Sir Michael that all of his grounds that he appealed have no merit and they should be dismissed.
I should have had Ophelia's divorce lawyer, who that was anyway, in case I ever get married and have to divorce again.
She was the respondent. She had Mrs. Marilee Brennan Simonet.
Good.
Marilee, Maryllee, Brennan Simonet. Let me just quickly look and see if she says here what are the grounds for the divorce. Oh, he was 76 when they divorced and she was 70. Oh my God.
But he's too old to be so mean.
Yeah, that's all.
Like you almost dead and trying to carry the things.
Mm-hmm.
That couldn't be the difference in their ages. If they were 56 and
Yeah.
47 when they were married, they couldn't be 7 years apart when they got divorced.
Yeah.
They said at the time the ancillary matters came to be heard, so a couple of years later. This is the ancillary part when they, splitting the assets.
So I'm confused. So,
At the time of marrying, he had 5 children from a previous marriage, and she had 2.
can we look at it that he was trying to protect? Okay, so before they got married, that he was trying to protect his previous children's interests. Can it be looked at, I guess, from
Yeah.
that? Yeah, like he didn't.
Yeah,
if anything
but
happened,
then
he
you
wanted
see,
to-
you put the assets under a holding company, but then you ask your wife to assist you with operating those companies.
Oh no, that's different. Okay, no. Okay.
Yes,
understood.
that's where he went wrong.
He should have kept it separate. Okay.
He should have kept it separate, but he didn't.
Oh yeah. Okay, I understand.
And they
Hold
must
on.
have been adults at the time when he got remarried. Why didn't he just distribute the funds to them?
Wow.
But you can't see the man like money.
Yeah, he still wanted.
Yeah. So he
Yeah.
wasn't protecting, he was protecting it wasn't protecting his children's assets. He was
Himself.
protecting his little egg.
Yes, his
Okay.
own interests.
Wow.
Mhm.
I'm trying to see if she stated in here. Let me see something.
He was
No.
a successful man though. Good for him.
Yeah,
Wow.
yeah.
He sure owned a lot of stuff
Yeah, that's a lot.
Yeah.
from construction and being a pastor. Maybe I need to go be a pastor.
I think that's it.
Why you don't stop?
I try to look for it. Come on.
Oh Lord. I'm
Ugh.
trying to see. Yeah, he transferred his assets to the company before they got married. Let me see. He said here, after my wife Myrtle died, I was contemplating getting married again. The few pieces of property which we had together, I transferred to my children by way of a company called Chisholm's Holdings Limited, in which I hold only 5% of the shares. The property in that company name is exhibited at so-and-so. So in that Chisholm company, Chisholm Holding, he had 2 lots in South Beach, valued at $185,000. 2 lots in Little Creek, South Andres, valued at 25,000, given to him and his wife by their grandmother. In 1990, say he and his son as trustee purchased a piece of property in Coconut Grove, Angleton for 18,005. So those were the properties that were in that holding company.
Hmm.
Yeah, let me see.
I don't understand how she helped with them. What she did, mow them?
She was the secretary, eh? Like a
Mhm.
secretary.
Yeah, but those were vacant lots. So I don't understand how she,
Yeah, he had a construction company too. I think she helped him in that. I think in here somewhere she talked about how she helped promote the company.
Mhm.
It's long. 40
Yeah.
something. So in addition to his substantial assets, he had a bank account at Commonwealth Bank in excess of $100,000. He had savings account at Bank of the Bahamas and Royal Bank, and he had money in the central bank.
Oh, wow.
But when he sent in his listing of assets, he failed to disclose those things.
So
Hmm.
here, how do we know we're showing everything? I know she came up and added some items, but how do we know that I guess the court, how does the court know you have everything outlined?
The court
I guess-
wouldn't. Then it would be up to
They
her.
don't.
Wow.
No, it would be up to her to say there are others.
Right. And even if she doesn't, because sometimes the wife doesn't even know.
If you don't know, you don't know. But when you
Wow.
find out,
But I think you're supposed to disclose. I mean, are there no ramifications for lying about your assets?
there is, and that's what he had. That's why he had to pay the price
Yeah.
because he didn't disclose. He didn't disclose adequately.
Yeah.
And then she was paralyzed and he didn't want to pay her. Maybe that's why he's getting rid of her.
Seems like she got paralyzed after. Anyway.
Huh?
Seems like she got paralyzed or ill after, like after this whole divorcing. Not
She
a,
said I'm a diabetic and paralyzed in about 2008.
oh, wow. Oh, but what?
They got married in 1998. She was
Mhm.
paralyzed in 2008.
Okay.
He got 10 good years.
Yeah, but you know, he's a pastor and a construction man, so
Mm.
I think he looking for something else.
Not good.
Whatever.
Not good.
You all, you, I don't
And I bet if he was the one who was paralyzed, she would have stuck
Should've
by
been.
him.
She
Oh,
would have
yeah,
been
right
right
there.
He would have
Right
stuck by him right there.
Right there.
Boy, I tell you. These men.
Let me see what else she say. Say his treatment towards her drastically changed when his adult children began interfering in the marriage, so that the petitioner became physically violent towards her. There you go.
Oh, no,
Mm.
no, no.
Mm.
So she said on the petitioner's promise, she gave up her career, and I already read that to you. She used to clean windows, mow lawn.
Mm.
She acted as collection agent. She did court appearances. She did eviction, inspection, all of that. She is responsible for all administrative work. She is required to solicit door to door, street to street for new business on behalf of J&J Chisholm. He really work her.
Yeah.
She was really working.
Sounds to
I
me
better
like the
not come
kids wanted to
across
sell.
him.
Say what?
I was saying it sounded like the kids was trying to get out for the stuff.
Yeah. But he worked her to the bone. He worked her to the bone. Because even in terms of the buildings that they had, she bought all of the furniture for it. She did it all herself. She said, the petitioner and I further agreed that the management and operation of the lodge would be my sole responsibility. I made the application, did all the work necessary to obtain the hotel license, the business license, the liquor license. I was solely responsible for the marketing of the business. I did international promotions, not only for the lodge, but for Auckland and the Bahamas as well, by the way of Ministry of Tourism. As a result of my ownership of the lodge, I was selected to be a member of the Bahamas Old Island Promotion Board as an arm of the Bahamas Tourism Department. She was busy.
Yeah, and she put
Wow.
forth her case well.
Yeah.
She said
Yeah.
she arranged fly fishing and deep water fishing tours, cooking, cleaning, with help and the general operation of the lodge. She promoted the bone fishing. She said together they purchased the bonefish boat. Yeah, she did a lot. Did the evidence bear out the fact that the petitioner certainly brought more financial to the marriage than the respondent. However, the respondent through monies worth brought great assistance to the marriage. And it would, in my opinion, be an extremely costly thing to hire persons to perform all of the duties and responsibilities that the wife performed.
And all that she did, she still wasn't good enough, eh? And you'll find
Mm.
somebody who'll blame her and find fault in her, because it's always the woman's fault.
Hmm.
Yeah.
Right.
What could she do if she have a stroke and she's paralyzed? There's nothing she,
Wow. No.
Terrible.
yeah.
Anyhow.
But I thought I would leave that one for last.
Yeah. Interesting.
Yes. So if you're interested, I can send you the Supreme Court case. And then the Court of Appeal where he appealed. If you wish, to
Okay.
read. They're long. So if no objections, I'll send you Fin Ethic. I'll send you Videnta, that the parent was held responsible for the damage from the mines. And then I'll send you the Chisholms, the husband and wife.
Okay.
Oh, Lord, you said it ain't that hard.
No, it's fine.
All right, so next week's class will be very short because it's only on company compliance. So I won't keep you all as late as I did today.
I have a
Just to
question.
confirm, sorry. Go ahead, Althea.
My question was, Miss Archer,
Yes.
when
I'm
you
listening.
marked our paper, did you write up all over it?
In some instances, yes.
Could you kindly send my paper? Let me see what you write, please. Just so I just want to know where I was, like if I was on a straight and narrow or I was all over in the bush.
Okay. Okay, I can do that.
Okay, go Denise.
Alright.
I just trying to find it. I just want to confirm the capstone in our final exam is April 15th. Is that correct?
Yes.
And the table A that we are supposed to be referring to, as you made mention, the latest version, could you please confirm if that's the one that's headed commencement 1st of October 2007? Companies Regulations 1985?
What are you referring to now? The Companies Act?
Oh, no, the link you gave us
Oh,
with
that's the UK.
respect to, I mean, I found it kind of difficult to find what was the latest table A.
I thought the link I sent you directly to it.
No,
Let me check.
when I copied and pasted that, it just
Uh-huh.
opened it up to one whole heap of them. And I'm just wondering if 2007 is the latest and if it's called Companies Tables A to F Regulations.
Let me look. Because when I pulled it up, it just had the latest amendments that were made.
Oh, amendments. So,
Mhm.
yeah, I don't know. So, I don't really understand how to read that, Christine. Like, so print all of those off and look at them as one complete document?
No, you can start by looking at the Companies Act if you wish. You
Yeah,
can,
well, we got to, right? So,
Right.
because the whole purpose is to determine
can be
which
made.
amendments could apply to
Apply.
our articles.
Yes. Let
So
me
we
let-
would have, yeah, go ahead. Yeah, I
Let me
just don't know which one of those. Okay.
let me look at the link what I sent you, because when I looked at it, it just had amendments. But I know when you look at these things again, they do all kind of things. They jump all over the place. So let me
Maybe
look
it's just my head. Yeah.
let me just look and see if it has the amendments again. And if not, then maybe what I may do is copy and paste the amendments. So make it
Okay.
you.
Okay.
and share it with everybody.
Yeah, that might be good, just to make sure we're all referring to the same thing
Same.
and it's a, you know, productive exercise instead of just a laborious, not productive exercise.
No, it's not supposed to be laborious.
Right.
Okay, I could do that.
That would be great. Thank you.
Okay, not a problem. Anybody else? Only 2 more classes to go. Getting there. Mm,
So 2 more classes to go. Today is what, the 11th? 7 more days is the 18th, and 7 more after that is 25. So we break from the 25th to the 15th?
yes, unless you want it sooner. I could change it.
That would all depend on the final class and I see how much guidance you give us.
Well, that's,
I'll never do another class again. This is so stressful, huh?
it is not. No, I mean, some
Yeah.
people say because they're so busy, they haven't had time to even study or read. Some people want that time. Some people prefer to just get it over with. So you all can tell me.
No, don't matter how much time you give me, I'll wait to the last minute anyway.
Yeah, so it's set on April the 15th, so that'll be right
That's
after.
fine. Right after Easter? Oh my God, that's gonna be on my mind all Easter. God,
Well, if you all wanted to change, the class is here, so tell me.
I'll wait until after Easter. At least those holidays I could use to actually study.
no.
Agreed.
So have you made up your mind? I mean, are you still deciding on the format? Or did we say
Yeah.
1 question and the rest was multiple choice?
When we agreed that?
Yeah, I thought we all agreed multiple choice, Miss Archer, is what everybody said.
They did.
Girl, where girl, but we
Yeah.
know multiple choice. Try out, let me try. Run on with something for 19 pages. Eh?
Oh my God. Okay, I dropping you off of WhatsApp for that.
Oh,
Block.
God.
As if she put multiple choice and I can't remember the answer. I can't make up a story. I need to be able to make up a story.
At least if you could
Crikey,
make a story, right?
no,
At least I can
No,
remember
and-
a little case, something, and talk about it.
no, at least with multiple choice, you got a hope in hell of getting something right. You got, I mean.
But yeah, you got a
Jesus,
point.
No way. Are you kidding me right now?
Yeah, but share's gonna be
I'll
on the
take
shares. It's very
100
long.
multiple choice. I don't care.
Oh,
I'll take
damn.
100 multiple choice questions over 2 essay questions on this literature.
Well, what
Yeah, you got a
Anyway.
point.
hold on. Let me see when I'm drafting this. I'm drafting this exam on the 16th. That's this week.
I can
Well.
send you a bouquet of flowers and some cupcakes here, make you feel sweet.
So what is it?
Oh.
What's-
Huh?
I can add some multiple choice if you want it.
No, I
Yeah,
don't want
be
to add
optional.
it. Yeah,
It'll be optional. So if those who just want to do scenarios, you could just answer the scenario questions. And if someone want to maybe, I don't know, I could replace maybe 2 scenarios with multiple choice questions. So you'll have a choice. That sounds good?
Yeah.
Okay.
You don't sound like you're giving us a choice, sound like you're giving us a combo.
No, it'll be a
That's what
choice.
that sounds like.
No, it's a choice. You can answer all of the scenario questions, 5 questions, or you can answer three scenarios and answer the multiple choice.
That's why I say combo, yeah, uh-huh, okay,
That's the
all
well,
right then,
hold on. I just get it now. You want
right,
all multiple choice.
absolutely.
Oh, Lord. What's the consensus?
Okay,
Yeah, I like the mix sounding good to me.
I
Okay.
like the mix too. Yeah, the mix.
They want them.
Goodness.
Hold on, but the mix is the choice. The mix is the choice. Either you're gonna do a scenario or some multiple and 2 questions or something like that, right?
Yeah,
Three
Oh.
questions.
Oh,
3 questions.
oh.
What we
But they're
talking
not
about now?
difficult. Come on. And out of the 3 questions, out of the 5, you can choose.
Mhm. Okay, that sounds good.
Just do not leave my share questions. Students
That's the
just like
questions I was gonna leave.
students like to run. Do not run from my share questions.
Buddy.
I got on my Nike sneakers right now.
I can put some of them in the multiple choice.
Ah,
Still get you no matter what.
yeah,
So
all
next
right.
week, and I'll see you all then. Okay. Have a great
Okay.
weekend. All right.
Thanks.
Bye bye.
Okay, all right,
Bye.
bye.
All right.
Thank you. Have a good weekend.
You too. but mine don't hurt us completely.